What are your thoughts? Birthright citizenship. What are your thoughts? And will you accept it if it rules against you?
Well, I guess I have to accept it's the Supreme Court, so I'll accept. I think it's very bad for.
Stop scrolling right now. The Supreme Court just dropped a massive hammer on birthright citizenship, and the immediate political fallout is absolutely unprecedented.
Our nation, we're the only nation that does it. No other nation does that birthright citizenship. No, not even close. Some did it, they ended it. It's tremendously destructive. It's extremely costly. I don't know, it's up to them. But in terms of for the good of the country, it'd be great if they didn't allow it. It would be great, but I can't tell you.
Wait, did you catch that subtle shift in his posture? Look closely at how he leans in and completely shifts his tone when discussing the finality of the Supreme Court's decision. It is absolutely fascinating to watch a political figure of this magnitude navigate a constitutional roadblock in real time. Instead of going entirely on the offensive, there is a very calculated pivot here. He acknowledges the institutional authority of the court, but immediately lays the groundwork for how this impacts national security and resource allocation. If you listen to the exact phrasing, it is clear this isn't just an off-the-cuff reaction. It is the planting of a rhetorical seed for the next campaign cycle. The strategic framing of birth tourism is a concept we are going to see amplified massively across different media ecosystems over the next few months. It completely reframes a deeply complex constitutional debate into a straightforward economic argument that resonates instantly with everyday voters.
We need to expand the Supreme Court, and here's why. For decades, the Republican Party has been chipping away at the foundation of our democracy. They use broken rules like the filibuster and the Electoral College to control the White House and Congress, even when they win fewer votes. And Mitch McConnell made up new rules so that Republicans could hijack America's Supreme Court, turning it into an extremist 6-3 conservative supermajority. Republicans steal power to ram through an extremist, unpopular agenda. This is not a court that represents the will of the people.
Look at the visual production value of this message. Notice the specific imagery being used in the background graphics, the scales of justice literally tipping under the weight of specific political figures. This is not just a standard political disagreement. This is a highly coordinated, high-budget push to fundamentally alter the structure of the American judicial system. By framing the current court as completely hijacked and illegitimate, the groundwork is being laid to normalize the idea of court expansion. They aren't just arguing against a single ruling. They are arguing against the institution itself. It is a brilliant, albeit polarizing strategy to energize a political base. When you start hearing phrases like extremist supermajority repeatedly, it is a deliberate psychological anchor meant to slowly degrade public trust in the established system, paving the way for what would be the most radical structural change to our government in over a century.
I am breathing a sigh of relief, but I want us to kind of widen the aperture a bit to understand the origins, the provenance of this challenge. It's part of this ongoing effort, I think, to address the demographic shifts in the country. I think it's part of this long-standing effort since the 14th Amendment was ratified to undermine it. We need to understand that this particular, the Birthright Citizenship Clause of the 14th Amendment is addressing the 1857 Dred Scott case. Charles alluded to this earlier. So we need to understand the ways in which these arguments are in some ways aligning with a particular vision of the country that we need to make explicit. That is to say that there are folks who are doubling down on the idea that this country must be a white republic, and they're doing it by any means necessary.
Hold on, rewind that logic for a second and really process what is being stated here on national television. Comparing a modern legal debate over executive branch overreach and constitutional interpretation directly to the 1857 Dred Scott decision is an incredibly heavy radioactive anchor to drop into the conversation. Look at the absolute conviction in his delivery. This is a masterclass in raising the emotional stakes of a legal ruling to their absolute maximum threshold. By framing the enforcement of existing border and citizenship parameters as a deliberate attempt to construct a white republic, the discussion completely bypasses any nuanced legal analysis of the 14th Amendment and goes straight for the moral jugular. It is a highly effective rhetorical tactic designed to immediately put any opposition on the defensive, forcing them to argue against accusations of systemic malice rather than debating the actual constitutional text.
I am breathing a sigh of relief, but I want us to kind of widen the aperture a bit to understand the origins, the provenance of this challenge. It's part of this ongoing effort, I think, to address the demographic shifts in the country. I think it's part of this long-standing effort since the 14th Amendment was ratified to undermine it. We need to understand that this particular, the Birthright Citizenship Clause of the 14th Amendment is addressing the 1857 Dred Scott case. Charles alluded to this earlier. So we need to understand the ways in which these arguments are in some ways aligning with a particular vision of the country that we need to make explicit. That is to say that there are folks who are doubling down on the idea that this country must be a white republic, and they're doing it by any means necessary.
Pay close attention to the visual setup here. You have the Speaker of the House, flanked by allied leadership, standing behind a podium to project maximum institutional stability. This is the exact opposite of the viral, direct-to-camera approach we saw earlier. This is a projection of defensive power. Listen to how methodically he walks through the mechanics of a constitutional amendment. He is purposely trying to cool the temperature of the room by drowning the emotional arguments in cold, hard procedural facts. By explicitly pointing out that amending the Constitution has only happened 27 times in our entire nation's history, he is actively trying to make the opposing side's calls for rapid institutional change look reckless and historically ignorant. It is a classic counter-strategy. When your opponents escalate the emotional rhetoric, you double down on process, tradition, and the sheer logistical impossibility of their demands.
This comes from Justice Alito, who brought this up during the arguments. This is his separate dissent. He said the court's interpretation also has national security implications. Suppose that a person's only connection to this country is that he was born here to a mother who was present just long enough to give birth and then quickly return to her native country. Suppose that country is a strategic adversary or enemy of the United States. Suppose the child never visited the United States while growing up and was inculcated with hatred of this country. According to this court now, that person is a citizen of the United States. He can enter and leave the country as he pleases. He can travel the world on a United States passport. Even if he plots to harm this country, he cannot be deprived of his status as a citizen, at least under current precedent. He goes on to say that this decision today also provides a powerful incentive to enter or remain in this country illegally. He goes on to say, in my judgment, the court has made a mistake that will seriously affect the country's future.
Did you notice the hyper-specific hypothetical scenario the justice introduces in this dissent? This is incredibly revealing about how the highest legal minds in the country stress test our laws. He bypasses the standard political talking points and creates a worst-case scenario involving foreign adversaries strategically exploiting a loophole in our citizenship definitions. By painting a picture of an individual raised in an actively hostile nation, inculcated with anti-American sentiment, who can freely travel on a U.S. passport solely because of a brief geographic coincidence at birth, the argument shifts from domestic immigration policy to urgent national security. It forces you to actually confront the absolute limits of the 14th Amendment's jurisdiction clause. This kind of judicial writing isn't just about interpreting the past. It is about aggressively flagging potential existential vulnerabilities for the future, daring the legislative branch to actually step up and close the gaps.
So you're talking about expanding to 13, and it's interesting. I mean, it is a great historical. And God bless
somebody
you.
Like you.
I'm with you. I'm done winning arguments. We got to win.
Yeah.
And we got to consolidate.
Check out the totally relaxed, casual environment of this podcast setting compared to the gravity of what is actually being discussed. You have a sitting governor casually endorsing the idea of expanding the Supreme Court to 13 justices, like they are talking about changing the rules of a fantasy football league. This casualization of radical institutional change is a massively important trend to monitor. By normalizing these massive structural shifts in low-pressure conversational media formats, it slowly removes the shock value for the general public. It makes the unprecedented feel completely ordinary. If you want to understand how Overton windows are shifted in modern politics, it rarely happens at a formal press conference anymore. It happens exactly like this. Relaxed body language, a couple of microphones, and a smooth delivery of an idea that would have been considered political heresy just a decade ago.
You think that it should be expanded for however many. He says 13 because of 13 circuits.
Oh, I've been saying for quite some time, I think that we absolutely have to explore what we need to do.
Listen to the incredibly careful phrasing being used here. We absolutely have to explore what we need to do. That is top-tier political maneuvering. She avoids making a concrete, hard-line commitment to packing the court, which protects her from immediate moderate backlash, but she leaves the door propped wide open to appease the more aggressive wing of her base. Notice her eye contact and the slight nod. She knows exactly how explosive this topic is. This is the delicate tightrope walk of high-level national politics. You have to constantly feed energy to your supporters without handing a perfectly packaged soundbite to your opponents. It shows that the idea of altering the Supreme Court isn't just a fringe internet theory anymore. It has fully breached the highest levels of the executive branch and is sitting right there on the active negotiation table. Drop a comment below. Who do you think actually won this constitutional showdown? Subscribe, and I'll catch you in the next breakdown.